case briefs, and so much more. LSData's got what you're looking for.
The story unfolds in 1998, when Boise, Idaho, resident James Henderson, a member of a traveling ice show, found himself caught amid a tax controversy. Henderson sought to deduct his on-tour living expenses as being away from home for the 1990 tax year. However, his claim met resistance. The commissioner dismissed the deductions, leading to a lawsuit that trickled down to the tax court. The tax court upheld the commissioner's decision, resulting in Henderson facing a deficiency of $1,791 in his federal income tax from 1990. The court maintained that Henderson could not use Boise as his tax home for deduction purposes, making the legal core of the case whether or not the expenses Henderson incurred on tour qualified as away from home. Rejected but unrelenting, Henderson pressed his case to the United States Court of Appeals for the Ninth Circuit. His argument pivoted around his assertion that Boise was his primary place of employment, thus making it his tax home. The court, however, clarified that only taxpayers with substantial, continuous living expenses and a permanent residence maintained for business reasons could claim deductions for travel expenses. Balancing the scales of justice, the appellate court ruled in favor of the lower court's decision. The judges pronounced Henderson an itinerant taxpayer and observed that despite his personal connections to Boise, his employment took him to various states and even internationally to Japan. Consequently, without a demonstrable business connection to Boise establishing it as a permanent tax home, Henderson could not claim his touring expenses as being away from home. Backed against a wall, Henderson found his travel costs from the Disney tours non-deductible, thus ending his quest for tax relief.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class